It's a pleasure to hear the counsels on both sides on various controversial issues, which are very in the case. What I see is that several issues have been raised in this matter, and the court ultimately is to decide whether this CO 272 and 273, whether they're constitutionally valid or invalid. That would be the direction of the court, and that would be the ultimate decision of this court, whether they need to be sustained or quashed. While making the submissions, the counsels have made at a different level of abstraction as to what possibly could be the grounds on which these two orders can be quashed. My approach would be to go on more fundamentals, the basics of it. The first premises, which to my mind is extremely important, is the existence of the state of Jammu and Kashmir at one point of time in history, and the formation of the Union of India at the same time in history. While as India was being unionized, Jammu and Kashmir state by itself was not a part of India, neither it was a part of British India. Now we have it clear from the various statutes itself, whether it's Government of India Act or whether it's Indian Independence Act, that state of Jammu and Kashmir not being a part of the Union of India at that point of time, nor was a part of British India. It was altogether an independent state. It had its own king, it had its own country, and it had its own laws. The king at that point of time would run the affairs like any other king of any other princely state would do. And the king of the state of Jammu and Kashmir, I will not go back too much in the history, also had certain laws which governed the running of the government. Either the state subject definition, which was introduced way back in 1927 and 1932, which applied only to the people who were residing in that state. Or from time to time, as has happened in all countries of the world, there have been changes, democratization has taken place, and ultimately the Constitution Act of 1939 was also promulgated by that king. And he created certain institutions in them, supposed to be democratic, but at the same time, he retained all the sovereign powers with him. This was the situation with us. Now, when Instrument of Accession executed, the circumstance in which it was executed have been already said. They are evident from the letter of 26th October 1947. What is the nature of that Instrument of Accession has already been read. What was retained and what was transferred or donated to the Union of India. And the subsequent letter of the Governor General dated 27th of November 1947 has also been read, saying that we'll put it to the people of the state whether this Instrument of Accession is acceptable to them or not. These are facts of history. Having said that, thereafter, after 26th of October 1947 till 26th of January 1950, we have no other document evidencing as to the relationship of the state with the Union, except this Instrument of Accession. What was sought to be stated by the respondents was that there was this proclamation of 25th of November 1949. The Constitution of India itself was adopted on 26th of November 1949, a day before. That has also been read today morning, and it was read earlier also. It said nothing except that the Constitution of India, as may be applicable to the state, would be acceptable to us. At that point of time, it was the successor of the king who was in chair, holding the position of the Maharaja. So when the Constitution itself was being debated, that's again historical fact. What happened in the Constituent Assembly, who said what, may not be relevant, but ultimately the decision of the Constituent Assembly was this, that they to have Article 370 for state of Jammu and Kashmir. To me, this decision appears to be the most significant and important because it answers several other questions. Why for Jammu and Kashmir? Why can't we remove it today? in 2023. What is so great about Jammu and Kashmir? If it is a part of India, why should it have a separate constitution? Why should it have a separate flag? Why should the President of India have to concur or consult in the matter of application of laws? These questions are answered by the Constituent Assembly itself, by the debates of the Constituent Assembly itself, and by the very existence of Article 370 as well as very existence of the Constitution of Jammu and Kashmir. Now, this is a fact of history. None of us can alter this fact of history. That is, in my opinion, the premises of this case. And as we proceed further, we find that this basic premise has continued over the years. Now, it's a separate question whether it can be done away with. And if so, in what method, by what procedures, by what process? That's a separate question altogether. The first is, as I would submit for Lord's consideration, this fundamental premise that the state of Jammu and Kashmir was different, Union of India was different. They agreed to join hands, but on certain conditions, which conditions came to be incorporated in terms of initial instrument of accession set later on by the Constitution of Jammu and Kashmir, as well as by the Constitution of India. Now, well, there was another factor, that was the matter went to United Nations and resolutions were passed. Those are also parts of your Lordship's Constitutional Assembly debates. Well, these matters were pending. The issue is this, that state of Jammu and Kashmir and Union of India agree so far as the integration. When I'm using this word integration, I mean in the sense of Article 1 of the Constitution of India, as well as Section 3 of the state of Jammu and Kashmir. While that stays, but I, the state of Jammu and Kashmir, should have the power to regulate my own affairs, accept what I have given to you. This is what I'm conditioned to that. So in instrument of accession, I gave you something. I gave you defense, foreign affairs, and communication. I gave it to you, make laws for it. But for remaining, I will make my own laws. Now, this was the position in 1950. If I put it differently, I had the ocean of, now later on today we call it now constitutional autonomy. Ocean of autonomy available to me in 1950. This is also a fact of history and an important premise in this case, that this position is accepted both by the Union of India as well as by the people of Jammu and Kashmir. I would also like to say something.
I just wanted to point out, look, we have referred to the history, we have looked at the content of the points.
The premises only.
But the fact of the matter is, ultimately, when the constitutional document is drafted and adopted and applied by the people of India, and we, the people of India, include the people of J&K, they're not separate from them.
Yes.
We are part, they will be obviously in people of India, there will be people from Punjab, there will be people from Gujarat, there will be people from J&K. Now, the only issue that may not really be, because we have moved with the passage of time, we have to move with the passage of time.
We have moved. That's what I'm saying. I'm coming to
moved.
that. Yes, I understand.
And now the question today is, really speaking, is the second part, which is Article 370, which is the main constitutional challenge before us. So let's confine ourselves to that.
It's a question of how the court is viewing the matter. Firstly, we're viewing the matter in a historical perspective, which becomes the foundation of this relationship between union and the state. Well, later on, over these 69 years, have this relationship moved closer? Has this relationship moved forward? And whether there is any possibility in 2019 that we could have done away with the relationship in a sense that Article 370 would go, Constitutional Jammu and Kashmir would go. Have we reached that stage or not? That I will indicate a lot.
We'll continue after lunch, but
Point number one, Milos.
yes. My notes of your submission this morning end with an ocean of autonomy, which I found very interesting a phrase. So I put it into inverted commas.
Milos, my first proposition for the Lord's consideration is this, which I said earlier also, and somehow there were different views on that. That's after the execution instrument of accession. Where did the sovereignty go? That's a very important point we want to make.
Yes.
Where did the sovereignty go?
So how will you formulate it actually?
Yes, that's what's one of the issues involved in this case, because respondents.
So we'll say
argument
that
is
the
different.
instrument of accession did not result in a loss of sovereignty for whatever reason. Now, what are those reasons? Let's just formulate them.
I'm not going to the reason. I will only cite the judgment of this court.
All right.
That's AIR 1962 Supreme Court 1288.
AIR?
AIR 1962 Supreme Court 1288. That is Prem Kumar Deb's case. There's also in the Your Lordship's documentation, rather in this case of compilation. Volume 6, I'm told,
Page?
number 10.
Volume 6 page?
Pages. Page 135.
135.
Yes.
This
Just
is
have a
the
look
case
at it.
dealing with the constitution of the Union Territory cadre for honor.
Yeah, there was some grant or something. What's important is that they go into this question when only instrument of accession is executed. That's all. No merger agreement, no supplementary agreement, nothing of that sort. What is its legal status? They categorically rule that the sovereignty will continue to vest in the ruler. This is what is in this judgment. Paragraph 11 of the judgment will also see that. Paragraph 11 of the judgment. I'll have read it, but I don't want to waste time. Because
Yes, you have read
I'm
it
told
already.
by my colleagues.
Yes, yes.
There's 11 expressly rules that. So on that basis, I'm saying, because earlier my lord's views were slightly different, particularly Justice Khanna's views were different. So I'm just citing the judgment, the constitutional bench decision, saying that the
You said 135.
paragraph 11,
PDF page 135.
PDF is what?
Which volume?
135.
Volume 6 said.
Volume 6.
Volume 6. Okay, I did volume 11.
Shah, these
No,
are
not
just
PDF,
questions and
just
queries. These are just questions and queries, just like you, this side, other side. These are just questions and queries, that's all.
No, my lord's asking me the question. I was just trying to respond to that. So my first proposition was that Maharaja retained his sovereignty. That's all I'm saying. Now, I also use the word, he retained residual sovereignty, if you lordship may recall.
Yes.
So residual sovereignty remained with him. Then what happened? After it was retained by the Maharaja, later on, at what stage it got transferred over to the people? It did not go into Article 1. It did not go into Article 370. That's what I'm trying to say. It has gone to the people. And it is in exercise of that residual sovereignty that the Constitution of Jammu and Kashmir was made. This is what I'm trying to say. It's incidentally meeting arguments of the respondents also that it was a concession, it was with our permission, so on and so
To
forth.
that extent, you're taking a different projection from others. There's a different argument as to what was argued by Mr. Sibal and others.
No, but on the question of sovereignty we are, I don't think there should be much. And it begins with the expression, we the people of state of Jammu and Kashmir. That should be enough to indicate that it is by itself an independent, separate constitution. But to say that this is inferior, to say it is subordinate society is something unpalatable to us, that we feel that this is our constitution, like people of India would feel proud that they have a constitution, which though in our case, we had proper elections. And then only we had representatives who made this constitution, unlike the Constitution of India, which was the no elections took place for forming Constituent Assembly. They were the representatives of various provinces. So we're on a better footing. Now, this constitution which we made for ourselves, what did it do? In section 3, it said, now we are calling our constitution section, whereas that of Indian constitution is articles. This is also another thing which has slipped into our language. Actually, my constitution also has articles. This section 3, straightway stated that it shall be an integral part. That's the same position as taken in Article 1 or Instrument of Accession. That's there. But what's important is that when it says we will redefine our constitutional relationship, which was read in the morning, it is in the preamble itself. Now, what would exactly mean redefining constitutional relationships? What was the earlier constitutional relationship which we had, and it had to be redefined. It had to be enlarged or reduced or whatever was to be done. So we have two different entities, the Union of India and a federating unit. Between them, this was the mechanism in terms of which they would redefine their constitutional relationship from time to time.
Not redefined, further.
Define, further define constitutional relationship.
Yes.
This has happened from time to time. That's why the CEOs explain that from time to time, there was further defining of the constitution. Prior to that, what we had was only Instrument of Accession, and then 1950 order, then 52 order, then ultimately they got merged in 1954 order. Subsequent COs are all amendments made in 54 order. They are not independent by themselves. Why it was so? Because 54 order had been initiated by the Constituent Assembly itself. One of the issues which Mr. Subramanian also pointed out, I have a judgment, division by judgment of the High Court of Jammu and Kashmir, where they've gone into this question that it was initiated by the Constituent Assembly itself. That you also will see. This is in AIR 1971, Jammu and Kashmir, page 120. Justice First Lady has gone into this question. I will just read it quickly because we didn't have time to add to your lordship, so I'll just read it. So I read it for lordship convenience. Lordship may not have a copy of it.
Yes.
It simply says, I, Yuraj, do hereby direct as follows. The Constituent Assembly consisting of representatives of the people elected on the basis of adult franchise shall be constituted forthwith for the purpose of framing a constitution for the Jammu and Kashmir. This was published in Government Gazette on 1st of May 1951. In obedience, this is court finding. In obedience to this proclamation, a Constituent Assembly was convened for the first time on 5th November 1951, as mentioned by petition para 13 of the amended petition. On 15th February 1954, the Constituent Assembly passed a resolution adopting the report of the drafting committee and the annexure thereto, and thus by doing so, the Assembly gave its concurrence to the application of certain provisions of the Constitution of India to the state in the manner indicated in the annexure. The resolution of the Constituent Assembly may be quoted thus. Then they quote that following Government of India. Now, this only leads to the conclusion that the process was initiated by the Constituent Assembly itself, forwarded to the Government of India. The President accepted this, and then 1954 extension order was passed. This gives the source, the history as to how this 54 order has come into existence.
Yeah.
After this comes into existence, then follow the later on, as many as in all, 54 constitution application orders have been passed. Out of them, this one is by the Constituent Assembly. Remaining others are by the government of the state. And those are in the nature of amending this constitution application order of 1954. Because they could not do it otherwise. This is another aspect you also need to consider. This was approved by Constituent Assembly. Others were not. So what they did was, all these years, they have been amending that particular order. Now, sir, as a result of these constitution application orders, what happens is that, which will also found interesting, ocean of my constitutional autonomy was reduced to a pond by 4th of August 2019, whatever it was. Maharaja just called it, it's a skeleton. I would not like to call it, but we still had. Now, what was that fundamentally I had on that date? Broadly, I have given that in writing also broadly. I had my own permanent residence was one. I had the jobs reserved for the people who are permanent residents to only in the state government services. Number three, nobody could acquire the land. These were three fundamental things which I had as on that date. Then, of course, we consider it to be our identity. This 370 was in the nature of the identity of the people of state of Jammu and Kashmir, culturally and otherwise also. Linguistically also, different languages were spoken in Ladakh, Ladakhi, in Jammu, Dogra, in Kashmir, Kashmiri. So over these 70 years, a certain kind of interaction, mixing up of these languages, cultures had taken place, and it had evolved itself into a certain kind of a culture, which is a complete harmonious relationship between these three regions. This was the effect from time to time, and nobody questioned these CEOs also for all these years, that why are you shrinking our constitutional autonomy? And I had raised an argument last time also. I said that by conceding that the Parliament of India will have power of legislation over me, I was indirectly reducing the power of my own legislature, which otherwise it had. Name any act. I gave an example, they had also TAD Act. My own legislature could have made it. But then this state cabinet recommended through the governor, you apply 97 in a specified manner, and we had Indian TAD Act applicable to us. Of course, that's the fate of the history as it is. But whatever was left, it was there as on 4th. Now, when you take this decision, what is to be done on now 4th? Somebody took the decision that we want to get rid of it. Why should we get rid of it? That I still don't understand. Why can't the Union of India accept there can be two constitutions? Why can't Union of India accept that it's a kind of a federation in which there can be two constitutions? There are examples all over the world where there can be two constitutions. It is not this solitary case in the world. Why can't that fact be accepted? Third, when you accept that you are an integral part of it, yet you have this constitutional autonomy between total integration, total merger, and some space between the state and them for historical reasons, not of its own, for historical reasons. That's an important part of it. So therefore, there were some problems, some circumstances, rightly said by the respondents themselves, there were circumstances, situations in which it was felt by whom? By both the leaders of Union of India as well as the leaders of Jammu and Kashmir to provide this space for this autonomy to the people of the state. We're not going to the why this autonomy was given, but the fact of the constitutional position that this autonomy was given to us. And this autonomy could be taken, as all the councils have correctly stated, by concurrence, by consultation. You could take it away from us. We had to concede. We were on the giving side because it was with us. We had to donate. We had to surrender our power. The Union of India had not to do anything. It had promised only what was in the constitution. List 2 would apply to you, that is all. There was a promise not specifically to state of Jammu and Kashmir, but all the states in India. That's how the constitution was framed. But so far as our constitution is concerned, we had to donate from time to time this power to Union of India. So both had to agree. Now take a look at 370 by and large. I'm not reading because time is less. Because 370 talked of three things. One, you need consultation, concurrence, and recommendation. 3 words are used. This is one side. 2, who are the institutions involved? You have the President of India, you have the government of the state, and Constituent Assembly. 3. All the provisions will also, which only 3 authorities are involved. But this government of the state is further requiring, in terms of the explanation, that it means a person who is recognized President of India, who has aid and advice of the Council of India. I lay emphasis on this, that this is a mandatory, indispensable part of Article 370 that you have to have in all situations. 356 or no 356. You need to have aid and advice of the Council of Ministers. You cannot make any CO without the consultation, without the concurrence of the Council of Ministers. I'm laying emphasis on that part. Yes, sometime back there have been out of 54 constitutional application orders, there were about 6 of them which were passed when state was under governor's rule or president's rule. But our stand on that, they were questioned. Before this court, I am told that some writ petition is pending. They were questioned Jammu and Kashmir High Court. The things remain. People did question them. Of course, they did not reach the logical conclusions. But at the same time, I must say that if they are unconstitutional, they can be questioned at any point of time. Law of laches does not apply to when the statute is unconstitutional or any action is unconstitutional. So even today, when we see this constitutional application of 2019, and we are questioning that, so we are free to question that on the basis that it was done without Council of Ministers being in place. This is the crux of our argument in this case. That's why I said earlier that let us go to the fundamentals. That the fundamentals in this case are this. Number one, that for this kind of change, which was made, it is not relatable instrument of accession, therefore consultation was not required. Concurrence was required. It is a mandatory requirement of 370, number one. Number two, the definition of the government given only for purposes of 370. I must make little digression here. We have government of the state under the Constitution of Jammu and Kashmir. And we have a far better provision there. That is section 35, which says, sir, that the governor will act only, the word used is only, on the advice of the Council of Ministers, which was not, you also will not find it in the Constitution of India at all. That way, how better our Constitution is. What your lordship is ruled by judicial decision, that the advice of the Council of Ministers is binding on the President. Our Constitution already way back in 1957 contained this provision that it should only act on the aid and advice of the Council of Ministers. Now, what do you do? So it means that the governor could not act without aid and advice of Council of Ministers in our Constitution. And here in this case, the governor acts. Fundamentally, apart from the other jurisprudential basis of the submission which have been made very at a different level, fundamentally, could they do that? Could the governor at that point of time do that? Now see more additional reasons. At that point of time, I was under 356 President's rule. What is its effect? Leave the 356, or what does it contain 357? My legislature is not my own, it is taken over by Parliament. My governor is not my own, his powers are taken over by the President. My government of the state is not my own, it is taken over by the President. All this is taken over by the President. Then in terms of 370, who gives concurrence? And who accepts that concurrence? We have a judgment of this court saying that when 356 is there, the powers are taken over by the President. How does he act? The President will act on the basis of the advice of the Council of Ministers, and this Council of Ministers is like the cabinet of the state government. If this be the correct legal position, it all means all is rolled into one, that is President of India. So it violates on the face of it the text, the requirement of Article 370. Forget for the time being, of course, without prejudice to what brilliant arguments have already been made, without prejudice to them. How could the President of India, when 356 is in operation, act on the advice on the recommendation made by Governor of Jammu and Kashmir, which governor had the status only, some, your lordship, some decision describe him as an agent of the President during 356, or some judgment to say that he acts as the President. In either of the situation, he is not the governor who has aid and advice. So for purpose of 370 and for purpose of other functions of the government, I respectfully submit there is a difference between the two. Specifically for 370, you need Council of Ministers. I'm not able to conceive of a situation where there cannot be Council of Ministers. That's the third thing. And the fourth thing, which is very important, is this, that you have applied 367 and modified it and applied it. Now, for the consideration of my Lord Justice Khanna in particular, my lords have been observing. What do you think of 3(1)(d), where you apply constitutional provision with modifications and exceptions? I'm saying something else. You first applied 367 by virtue of 3(1)(d). You applied that to which provision? You applied that to subclause 3 of 370. Subclause 3 says, notwithstanding anything contained herein above. The question which immediately falls for consideration is, if you have carried out a modification in terms of 3(1)(d), but applied that modification to subclause 3, when the 3 says notwithstanding anything contained herein above, isn't that 367 modification excluded from application to subclause 3 of 370? I'll consider this aspect of the matter. When it says notwithstanding anything above would mean also any constitutional application order issued under 3(1)(d) will also not apply when you want to act under subclause 3 of 370. So therefore, on that basis also it has to be faulted. So therefore, I am submitting is going by the basic premise, the basic principles, that this action of 272, it does two things. Best part, then the last thing which I want to submit to Lord's consideration is one more thing. This power of concurrence. I say, for your Lord's consideration once again, in 1957, we adopted our own constitution. Prior to that, we had Constituent Assembly. As rightly said, Constituent Assembly can do, undo things because it is not subject to any fetter. There is no control on a Constituent Assembly because it's free to evolve and deal with its affairs. But after the Constitution was adopted on 17 November 1956, I'm submitting this. The state government comes into existence under the Constitution of Jammu and Kashmir. But at the same time, the state government is required to give its concurrence or consent under 370. I say my constitution, Jammu and Kashmir constitution, is in the nature of a limitation on the power to give concurrence after 1957. Meaning thereby, even if there was council or minister in place as on today, they also could not give any concurrence because it is subject to the limitations of the Constitution of Jammu and Kashmir. Now, what are those limitations? On the prima facie, I will show. If you also will have a look at 272. The first part says, the Constitution of India as amended from time to time shall apply, subject to the modification as follows, that is 367. Means the entire Constitution is made applicable on the so-called invalid unconstitutional concurrence of the governor. When you do that, you are contradicting Constitution of the state. And when you are contradicting Constitution of the state, there is a limitation in your power of giving concurrence under the Constitution of the state. Meaning thereby further, that our Constitution had to stay. It had to permanently stay because the state government no longer could give its concurrence in contravention of the provisions of the Constitution of the state. That limitation will have to be read into this power of concurrence after 57. Of course, there will be provisions which don't come into conflict. For example, take the High Court. Somebody cites the example of the High Court. Now it is established under my Constitution. When you say somebody gives concurrence, the Article 215 of the Constitution of India will apply. It comes directly to conflict with my Constitution. The question is not that that is superior, I am inferior. No, the question is, did I have the power to give the concurrence for the application of 215 or any other provision of the Constitution of India? My submitted lordship says I am controlled in my concurrences now. I am controlled in my consultation is something different that relates to instrument of accession. But in respect of application of these constitutional application order, I am controlled today by the Constitution of Jammu and Kashmir. So therefore, on that second ground, also I say that this 272 as well as 273 are both are constitutionally absolutely invalid. Now, my lords, observe that, okay, you are still in history, let us progress further. Isn't this COs issued 54 in number from time to time? Isn't no, it was not a step in right direction. I put it to myself. It was getting closer and closer. What made you to do it on 5th August? It is not still forthcoming. And there is something more to it also. You also may recall, I said, when this concurrence is given by the government, this Governor of Jammu and Kashmir as stated in the text of 272 order. When was that concurrence given? Who gave that concurrence? What was the nature of concurrence? No material that is concealed from this court. No material is produced before the court. It is not in their affidavits. Despite having been stated in the petition that, look here, we want to know who gave this concurrence. What is the date of that concurrence? Who signed that concurrence? Was it done 1 day before? Was it done 10 years before? Who gave that concurrence? We are entitled to know it. This court is entitled to know it. There is no material on that basis. So therefore, that apart. But further than somebody says that we have given the concurrence, it doesn't look legitimate. It doesn't look sustainable. It looks all against the Constitution itself. Then lastly, I would like to submit, many statements were made here. Insofar as the development is concerned, I have only one thing to say to our learned friend, Solicitor General of India. They say self-governance is better than good governance. That's all I can tell him. Give us our self-governance back. That's number one. Number two, somebody also said it here, it is very important. Nation has to grow. We can't waste our time. We want to have a unified nation. Of course, very noble thought, very good thought. But then for that, you have to win over the hearts of the people. You cannot form a nation by force, by compulsion. Win the hearts of the people. If your Lordship decided this matter in favor of the petitioners, your Lordship will be going a long way in winning over the hearts of the people of Jammu and Kashmir. That's all I would thank.
Thank you, Mr. Zafar Shah. Dr. Bennett?
Just a minute. Just a minute. Just last thing, Milord, only last say that. What initially we were promised, I just look at it from another perspective, and the people who like to know that. What initially was promised was we'll put Instrument of Accession to a referendum. It was not done. They told us, not people of Jammu and Kashmir. It was Governor General's letter. They took the matter to United Nations. They said, go for plebiscite. It is not done. Now, after that, this constitutional autonomy was left all these years. But in 2019, that is also taken away. Who has lived up to his commitment? The great leaders of India, Jawaharlal Nehru and Patel, they were statesmen. They were not politicians. They made these commitments to the people of the state of Jammu and Kashmir. It is in parliamentary debates. It is outside the parliament. It is everywhere. But now today, since there are no statesmen left, we have politicians. Decisions have been taken. People feel betrayed. That's all I can say. Thank you.